So what my task here today is to give you some information about the legal aspects of this. So I hope I can at least make it a little interesting and not just dry legal matters. But I will start with saying that this amendment is not about gay marriage. That's basically really the first place to start from. It really is not about gay marriage. There is actually about 3 categories of amendments that have been passed across the country. And the first type does simply prohibit marriage between same-sex couples and says that marriage is only a union between a man and a woman. This is not that type of amendment. The second type of amendment not only prohibits marriage between same-sex couples, it also prohibits any legal unions, civil partnerships. They're not going to give any recognition status to those. Our amendment is not that type of amendment. We're in the third category of amendments, which not only prohibit same-sex marriage, prohibit any form of recognition of a legal status, a partnership status between same-sex couples, but it also prohibits it for all unmarried couples. So who's really going to be affected by this amendment more than the gay community is the straight community, those unmarried couples in our state. And according to the last census, there was about 186,000 cohabiting unmarried couples in North Carolina. And of that, 90% are straight. So there's 90% of that 186,000 are the ones who are going to be affected by this amendment, and it's only 10% who are same-sex. Although the census reports about 27,000 people reported as living with a partner of the same sex in the last census. So let me also start with dispelling a myth or two, and the one that I really gets to me is, marriage is this institution that has never changed for centuries and centuries. And as I'm sure we've all witnessed in our own lives, that is certainly not true. I won't even go back and start with when the church started recognizing marriage and encouraging marriage for various reasons and the economic and social reasons way back when in the Middle Ages or so. I'll go back just to what I learned in law school, which was that marriage creates a unit, and that unit creates a unit, and that unit is one, and that one is the husband. That's what you learn in law school. And literally because that was true. I mean, it used to be that women had no contract rights, no property rights. She was not a legal entity. She was not even considered a legal entity. And even when I got out of law school in 1976, here in North Carolina, if a couple separated, in terms of property division, it was whosever name was on the property, whosever name was titled. And back then, most all property was titled in the husband's name, so the husbands could walk away from marriages with whatever property was titled in their name, even if the wife had contributed her own money to purchase that property. So that was where we were even back then. Fortunately, obviously, we know that's all changed, and women are legal entities. And it also, as a side, is children. Children used to also not have any legal rights that were property of the father, husband. And also, we can look back not too long ago at the prohibitions against interracial marriage, and that there literally was on the law's books in almost every state that prohibited interracial marriage. We look back at that and shake our heads and can't believe that happened, but it did. I do take note it took 25 years from when the California Supreme Court was the first state to outlaw interracial marriage, and then 25 years later, the Supreme Court finally weighed in on it, and said that no states could do that. So I'm hoping in this fast-paced world that we'll condense that down. And since we've already got 7, 8 states, it keeps changing that are recognizing marriage. I think we'll see the Supreme Court weighing in on that not too long. So certainly, marriage has changed over time to reflect the cultural and social attitudes of the day. And I also just throw out there, just for thought, is public policy considerations like should we be penalizing people for not marrying? Should we almost be forcing people to marriage just to get government benefits? Is that a good public policy? Essentially, the goal of this amendment is to maintain the privileged status to those who do marry and keep it an exclusive club, and then meaning they are the only ones who get such benefits. And there are many reasons that people don't get married: personal, complicated situations, loss of alimony or support, child support, loss of government benefits, loss of Social Security for elderly couples, immigration reasons. So there's many, many reasons why people have to choose not to marry, and under this amendment would really suffer even far more consequences. So my soundbite for, you're always supposed to have that elevator conversation for when you get 2 seconds to talk to someone about this amendment. My soundbite is that this amendment would prohibit all unmarried couples and their families from creating legal protections for themselves. So not only is it not giving any new protections, it is taking away protections that individuals have been able to have. To understand the impact of that, I'm just going to quickly do the quick version of the legal aspects of this in terms of what the current laws in our state are, what we used to be able to do for unmarried couples and their families, our current sort of situation, and what happens if this amendment passes. So quickly, marriage laws nowadays in terms of custody and child support. Obviously, if you're married, there's a presumption of any child born during that marriage is the child of both those parents, even when it is obvious that the husband was not the biological father. He would be presumed to be the father if they're married. We have a very systematic laws about when you divorce, how you divide up property. It's all very set, and most times we don't go to court because the law is so clear. You divide property 50-50, so there's no question about that. You get alimony, you get inheritance, you get all sorts of benefits. I like this one thing that years ago I got from one national group, and it says, "Congratulations on your marriage. To honor the special occasion, the U.S. government is happy to present to you this list." At least this is just a showing of the 1,138 federal laws that you get when you get married. And then, of course, on the other side, if you're a same-sex couple, you get nothing in terms of federal law. So that's federal law. And on the state level, we've done some research, and there's probably over 150 North Carolina laws that benefit married individuals versus unmarried individuals. And so even in the states where you get married, same-sex couples get married, they still don't have the benefit of these laws. And there's new exciting litigation on that fact out from couples out in Massachusetts that, how can the federal government keep denying them this legal status that they are allowed in their state? So what we used to do back in the day when we were advocating for same-sex marriage, not having to defend against it, we developed various legal protections for a client. And the thing that I handed out, I'm sorry, not many, how many folks of you have been able to get it, but what we used to do was we would say, there's 3 columns on this brochure, and the one was the rights that you get if you're married in North Carolina, and what the legal status of same-sex partners were, that they had no automatic right to their partner's interest in property, they didn't have gift tax benefits, they couldn't visit them in the hospital, they weren't presumed the legal parent of the other, so a long list of comparing. And then we had this nice final column, which was what you could do because the laws wouldn't allow you to get married. Now, if this amendment passes, and that's why on the copies I handed out to you, have put a big X here, so that all these things that we used to tell clients that you could do a healthcare power of attorney, you could do a domestic partnership agreement, talking about how you own property if it wasn't one person's name but the other person paid money, how you could protect yourself if you were the one giving the money, you could create joint parenting agreements, you could do your wills, you could do will agreements, you could do all sorts of legal documents. And that's the biggest impact this amendment will have, is you won't be able to do those things because our amendment goes so far as to say anything that we're not going to recognize anything that looks like a domestic legal union. whatever that may be, whatever that may mean, which even in the materials that have been handed out to the Board of Elections explaining this amendment to anybody, it basically acknowledges that it's going to, the issue of what this amendment means is going to be interpreted in the courts for many, many years. So we're not even going to know if it passes what all the implications are. So that's going to be, and already we can see that in Idaho passed a similar amendment in 2007, a similar one was passed in South Carolina in 2006, and they have yet to be a final word in their courts as to what their amendments mean. So it does take years. And so in the meantime, we may see things like people literally leaving the state and moving out of the state, which is, we saw that when, unfortunately 2 years ago, our Supreme Court said that we couldn't do second parent adoptions anymore, whereby a second parent could adopt his or her partner's child, and invalidated all those adoptions we did. And literally many of my clients moved out of state in order to go to a state where they could get their family protection that they needed. So, and then we also see experience in other states in terms of laws such as domestic violence, that right now we do have protection in our domestic violence statutes for same-sex couples if they were living together. They're treated a little bit differently than unmarried straight couples, but there is still some protection. So not only will they lose protections, also all the other unmarried couples could. And again, you think this is maybe extreme, but after Iowa passed their amendment, actually because the statute had included recognition of unmarried couples, many men being charged with domestic violence, but many straight men started challenging the domestic violence statutes in Ohio and said, well, this recognizes our relationship and therefore you can't enforce this law against us. And it took years and years, and several levels going up, the men would win and have their cases thrown out. Finally, the Ohio Supreme Court has finally said that the domestic violence statutes can still be applied, but that has caused a big mess in Iowa. In terms of estate planning, again, the only way unmarried couples can get protections is to do documents. I mean, obviously, if you're married, the law has we have many laws that if your spouse disinherits you, you're entitled to go to court and get what we call an elective share. You're entitled to serve as executor. If your spouse died without a will, there's just a whole long list of things you get to, rights that you have as a spouse if your spouse dies. For unmarried couples, the only thing they can do is put it in the will. If they don't have a will, their property is going to go to their next of kin. And also, wills are important to name guardians of your children, to do powers of attorney, healthcare power of attorney, all of those things would be really called into question whether these documents, I mean, if the document is based in any way on the concept that they have a relationship, then this could be a real question. So even things that are coming up now, I used to put, or I still do, but clients are starting to ask me more about it. I put, I'm leaving my property to so-and-so who is my life partner, and not only was that good language because that was what in fact it was great to go and start educating the clerks of court and other court officials that yes, this isn't just a friend that I happen to want to leave everything I own to, this is, so it was a good educational tool. And now there's some thought we shouldn't put those in because then it would sort of red flag the wills and better not to say anything and go back to, just pick up this person that I want to leave everything to. So it's sort of, in a sense, going back in the legal closet at least. So, and again, these are, could sound like exaggeration, but I'll give you one other example. In Nebraska, they had with their amendment, the legislature was considering passing a law about who can dispose of persons' remains and organ donation, and the legislature wanted to include domestic partners in that, and so they asked their Attorney General for opinion, And the Attorney General said, oh, no, that would violate our amendment if you included domestic partners in the list of people who could do such things as have the authority to say what happens to a person's remains or whether they wanted organ donation or not. And the reasoning given by the Attorney General was because such decisions were traditionally reserved for surviving spouses, and granting such rights to same-sex couples would be akin to recognizing their relationship. So they stretch it even so far as into something like that. These are the kinds of things that we in the legal field worry about. I also read a statistic that 2/3 of North Carolina population lives in communities with less than 50,000 people. And that is where gay people live, and that's where their rights will be determined in front of local judges, court officials, and law enforcement. So it may be hard for us to believe in the triangle as we go around and see all the signs here, but life has not changed in some of those areas, and we're going to be giving a lot of authority to local officials to make those decisions. And I can tell you, just went down a year ago to Lee County, which is really not just south of Raleigh, not that far away, to do a custody case that involved same-sex couple, and the judge was, I thought I'd gone back into the 50s. So, and they have great authority, and they can decide, a judge can decide a case totally contrary to the law, or whatever way he or she wants to, and unless you have a lot of money to be able to appeal it, you're sort of stuck with what the ruling of the judge has made, and you really can't go back into court right away to try again. You have to wait a long time. So those are really concerns. A few other matters are employee domestic partner rights. There is, we can go into this more, there is a provision there was in the bill, but it's not in what's on the ballot, that says that that private contracts between parties, and including between business owners and employees, should be considered, but that's not on the ballot, so question whether is that going to become part of law or not. But so there's a question whether domestic partner benefits will be lost in the private sector, but clearly they will be lost in the public sector. So all the good local governments we have, particularly in this area, Durham, Chapel Hill, Charlotte, I believe Greensboro, all those places that have domestic partner benefits for their employees will be prohibited from giving those benefits, and will take those benefits away from those
Sharon,
employees.
would you read the text of the amendment?
Sure, yes, I'm sorry I didn't start out doing that. Our amendment that's being proposed on the ballot is just, well, what you're going to see on the ballot will be a for or against constitutional amendment to provide that marriage between one man and one woman is the only domestic legal union that shall be valid or recognized in this state. And that's, the words only domestic legal union is what we don't know what all the implications of that. It's not simply marriage. The bill that the legislature passed had the additional sentence that this section does not prohibit a private party from entering into contracts with another private party, nor does this section prohibit courts from adjudicating the rights of private parties pursuant to such contracts, which would mean, you could enter into some private contracts and the court should uphold it. But that section's not on the ballot, so that's going to be one, there's some confusion about that, and one of the many challenges that will probably pop up whichever way this amendment goes. Which I won't get into, sort of in conclusion, I won't get into naming names, and got myself in trouble at the last church I spoke in when I start getting into advocating who you should vote for. But one thing I do want to say, and it's not so much in the May primary, but come November, there will be many statewide judicial races on the ballot, and I urge yourself to educate yourself about who's on the ballot, because those are the people, that is crucial in this state, and those are the people who are going to decide the impact of this amendment. And there's some very important, one race in the Supreme Court, a couple races on our Court of Appeals, and a local one. So judicial races, as all of you know, get sort of slighted. So I hope that you will, in the fall, look at that. So I think because we've got some other great speakers, I'll stop now and just say that I hope that this has been helpful to you and will help you in discussions with folks you might encounter between now and May 8th. My pessimistic side hates that we are facing this scary legal and political possibility that will also be so hard to undo. As an aside, North Carolina did not ratify the amendment to the U.S. Constitution giving women the right to vote until the early 1970s. So that's how slow North Carolina can. Of course, it was a moot issue because it had already been passed by other folks. But it's, as even Speaker Tillis has said, if you follow all those kind of, he acknowledges this is going to be undone in 20 years. So we're going to go through all of this and have it undone in 20 years, which is a waste of everyone's time, money, and everything. And also that it creates this adversarial environment for all of us and doesn't really help with dialogue between everyone. However, my optimistic side is glad that we've had this opportunity to tell our story.